Hey everyone, the unit we'll be doing today is Unit 7, which is Business Law. The unit code is H6170736 and my name is Shazia Khan. So we've got 4 learning outcomes for this unit that we'll be doing, and we'll be starting off with the first learning outcome today, which is we'll look at the background and the nature of the legal system within UK, how it works and how it's divided into different areas and different jurisdictions and sections, and we'll be looking at that today, and then we'll go on to the other learning outcomes after. So we'll start off with learning outcome 1, which is looking at the indicative content for that. So firstly, defining a legal system. We'll also be looking at the purpose of law, the evolution of law and the different sources. So how law evolved historically, and look at the legislation, case law, and why there are different divisions of the courts and the difference between civil and criminal. Look at the justice system, the government and their role, and the organisation of the jurisdiction. And it's really important to look at the elements of the English legal system, starting historically, to identify the principles now. So what is the legal system? So the UK is divided into 3 main jurisdictions, contained or self-contained legal systems: England and Wales, Scotland and Northern Ireland. Each jurisdiction has its own laws, court system, lawyers and judges. However, laws that apply in one jurisdiction, particularly if they have derived from legislation, which are referred to acts and statutory instruments, may apply equally or very similarly in other jurisdictions. While the courts in each jurisdiction can decide cases differently from those in other jurisdictions, the final appeal for all of them goes to the Supreme Court. And the Supreme Court was adopted as the final court in regards to identifying how the law is implemented. Okay, so it's the final court and it's the one that deals with everything. So it's really important to identify to understand the UK legal system, because you need to be able to understand how the system works and what elements of the system mean. So it's procedures that govern. The UK system is comprised of several indispensable components, such as, like, when we're going to go through a little bit more, when we look at sources, legislation, case law, acts of parliament, courts, tribunals, so we're going to go through each one so you've got a better idea of what they deal with and how they deal with things as well, and why the UK is structured the way it's structured. The United Kingdom does not have a single legal system, since it was created by political union of previously independent countries. Article 19 of the Treaty of the Union put in its effects of the Acts of Union in 1717 or 7, which created the Kingdom of Great Britain but guaranteed the existence of Scotland's separate legal system. And we'll look at that in more details. So the purpose of law. So laws are the rules that regulate conduct and behaviour within society. So, laws have to be put in place to identify things. For example, if you commit a criminal offence, there's laws in place to say that if you've committed this criminal offence, you must be, sentenced for that. These apply to citizens and are enforceable by governmental authority, with penalties in place for people who contravene the law. Law has been defined as a body of rules or actions or conduct prescribed by a controlling authority and having binding legal force, that which must be obeyed and followed by citizens to sanctions or legal consequences is a law. The purpose of law. So it's really important when we look at any elements of law, why law is so important when we look at the purpose of law. So when we look at purpose of law, each type of law serves a distinct purpose and establishes a particular set of rules and regulations and principles in UK system. So there are different laws and values in place. You know, the idea of having, you know, having this law and is to keep society, you know, in place. And also, you know, when we have creations of case law, we have creations of, you know, we have creations of the different laws that come into place to prevent certain criminal acts. You know, different laws, they've come over centuries, you know. Ultimately, the legal system in the UK is there to uphold a fairness in society, and laws ensure that victims receive justice and criminals receive the relevant penalty for their wrongdoing. The end goal is to rehabilitate criminals so they are prepared to integrate back into mainstream society and to reduce the overall of reoffending, breaking the destructive cycle of crime. There are different types of law which have evolved over hundreds of years, as we mentioned, thousands of years, and you know it's believed that according to ENL, legal law helps ensure that victims of crime receive justice, as we mentioned, and criminals receive the relevant penalty. And a quote in regards to that was, many believe that a society without laws would be a society in a state of chaos. ENL legal states without clear authority, figures and punishments in place to deter people from, for example, stealing, anarchy would ensue. Any person could walk into a house and take your belongings with no consequences. Someone could take another individual's life and nothing would happen. So, you know, they're saying that without the laws and stuff, there would be anarchy, there would be issues of, without, you know, issues addressing back to how things there would be a form of chaos. So looking at the evolution of law, how it evolved over time, you know, so you know, the legal system in the UK is over 1,000 years old and has seen many changes. So until the end of the 12th century, the principle of trial by ordeal held sway in local and royal courts. A verdict of guilty or innocence wasn't delivered by a jury, but by God. The accused person was subjected to painful ordeal, and how they responded was seen as proof of God's verdict. So this was in the 12th century, and trial by ordeal involves practices like making the accused carry a red hot iron bar for 3 meters, or tying them to a rope and then plunging them into a pool of cold water. Another way of reaching a verdict in the 12th century was trial by combat, in which a victory was attributed to strength granted by God. So this remained in English law until 1818, but by this time it had mostly fallen out of use. And then from the first judges to common law, so up until the 12th century, the monarchy and judiciary were inseparable. They began to change with the creation of justice in the air. When Henry II came to the throne in 1154, there were 18 judges at that time in England. He sowed the seeds of the justice system we now today by creating local juries of 12 knights. Excuse me. At that time, their job was to resolve disputes related to things like land ownership and any sort of disputes between land. Henry also oversaw the creation of common law and legal circuits. Laws created in Westminster replaced local customs, and this new common law was implemented by travelling judges who went around the country's circuit settling cases. Then the King's Bench came into force, so Henry also created the King's Bench, which was a collection of members from the royal household whose jobs were to hear all complaints of the realm and to do right. So eventually this split into 3 courts: proceedings from before the king, proceedings before the King's Bench, and the Court of Exchequer, which dealt with royal finances at that time. Big changes took place in the 13th century, and the demographic of judges on the bench changed from predominantly clergymen to surgeons who had professional experience of the law. The class of surgeon was the 13th century equivalent of today's barristers and solicitors. Then was the birth of the magistrates' court. So common law isn't the only legal concept that was hung around since the Middle Ages. There are also magistrates' court, which were introduced by Edward I in 1285, so it's a very long time ago, which today carry out at least 95% of criminal cases. And then from the Wars of Roses to the Restoration. So the civil wars fought between the House of Lancaster and York, illustration of how the judiciary and the monarchy were slowly separating. Despite the impact of this conflict into English society, the judges remained separate, impartial, and largely unaffected. This trend continued through the Reformation, which strengthened the monarch's powers. On the surface, at least, the system was that the monarch made the laws and the judges interpreted them with an even hand. However, it would be wrong to say that judges weren't extremely mindful of the sovereign's opinion. In the second half of the 12th century, Charles II sacked 11 judges and James II sacked 12 judges. So judges had to learn quickly which side their bread was buttered on. So it was quite a hard thing, to deal with, to be honest, and, to be mindful of what's going to happen. Then the Court of Chancery came about. So if a person felt that they had failed by common law system, they could petition the king. Gradually, this power was given to the King's Council, and eventually to just one man, the Lord Chancellor, who presided over the Court of Chancery. Although ostensibly run on the principle of impartiality, it was vulnerable to the same problems as the common law courts, and it was the domain of one man. It wasn't as even-handed as it was present. Nevertheless, by the time of Henry VIII, it was used as much as common law. So the next big change was in the 19th century. In 1830, the Court of Great Sessions was abolished and the Old Bailey was established. This was the central criminal court which sought to bring together the judiciary in London and its surroundings. So in 1856, Old Bailey judges were given the right to hear local trials when it was believed they were unfairly influenced by local bias or could be settled earlier. And the county courts, which covers civil cases, which was introduced in 1846. Things were starting to resemble today's legal system more closely. This reached a head in 1873 when the Judicature Act merged the common law courts with the Court of Chancery. The Act was created the High Court and Court of Appeal. Along with the Court of Appeal came the right of appeal in civil cases. Rights of appeal in criminal cases were held off until 1907. Then the Crown Court was introduced. So today there are around 70 Crown Court centres in England and Wales. They deal with the most serious criminal cases. The first were founded in Liverpool and Manchester in 1956, with numbers ballooning in 1972 when assize courts and quarter session courts were replaced by Crown Courts. The seeds of the modern justice system were sown by Henry II, who set up 12 jury locals, as we mentioned. Comparing this to the 40,000 plus judges employed around the country today just shows how far the laws evolved over the centuries. Although medieval and inhumane, the first records of an injustice system demonstrate how there's been a need to uphold a peaceful society and for people to clearly know right from wrong. Fast forward into the 21st century, and society is the most civilized and fair it has ever been. Women can vote. There's a fair judiciary system in place. Human rights are protected, giving people a good quality of life and so much more. These laws serve as a norm of conduct for citizens and act as a guidance of acceptable behaviour. violate the law and there will be consequences to fit the crime. We need the law to ensure quality and assurance. It may surprise you to learn a fully independent judiciary, as we said, is now. It wasn't until 2006 where the Lord Chancellor was unable to act as both the government minister and the judge. And then this change was due to the Constitutional Reform Act. So you could see that when we're going through the history, how the history evolved around law, how there were, you know, more pressures on during the start of it, and how it was a long road to 1,000 years of getting to, you know, having a good independent setup now, you know, having the judges in place and how they fall, you know. So, you know, there's more laws in place, and the judiciary is officially in 2006 became independent from the government, which is a big thing, and it's historically, you know, it's something that's been going on for a long time. And it's made a lot of changes as the law in regards to how things panned about, and how much there was a lot of chaos at that time. So different types of laws around, they were around for hundreds of years, thousands of years. And it's still consistently changing now with society, despite any sort of flaws. You know, it's changed massively over time, as you can see through the evolution of Henry I, you know, in regards to the different changes of having local knights to judges, and then the Judicature Act, common law, things like that were introduced to try to implement and make the law better for individuals. So looking at the next one, which is sources of law. So the UK has a rich legal system that evolves over centuries and has many sources of law that shape its landscapes. Sources of laws can be defined as rules that govern the behaviour of human beings with a civilized society. So sources of law can broadly be categorised in 4 types. So we have legislation comprising of acts of Parliament and delegated legislation, common law developed through judicial precedent, European law is applicable before Brexit, and the Human Rights Act as enshrined in the Human Rights Act. And these sources interact and evolve over time, shaping the legal framework of the UK. The most common sources of law are legislation, case law, common law, and the European law. These sources encompass statutes and regulations, judicial decisions, historical practices, and laws derived from EU treaties and directives. The most important source of law in the UK legislation primarily is comprising of Acts of Parliament, which is known as statutes. These are written laws formally passed by the UK Parliament and have the highest authority within the legal system, overriding previous case law or common law. So if we look at the forms of legislation for the sources of UK legislation, we've got legislation, common law, again, EU convention, international laws. The UK system has a range of sources that play a vital role in shaping the legal development of the UK system. Legislation, common law, assimilated law, human rights, customary international law are important sources of the UK, ensuring that the UK legal system remains robust, adaptable, and grounded in both tradition and contemporary legal thought. Understanding these sources is essential for navigating any sort of complexities of UK law and appreciating its depth. So it's really important when we look at the sources of law, why they are so important, why there's need to have, you know, these sources of law in place, and, you know, what is the main source of law in regards to making decisions, and also looking at, you know, different sources of law, common law and things like that. Sources of law can be described as primary or secondary sources. So we'll go through primary sources first. So primary sources of law could be things like legislation, and case law. The primary sources of law refer to laws themselves, which comes from official bodies. And it generally includes treaties, court decisions, tribunal statutes, regulations, court records, legal texts, and government documents. The following are the primary forms of UK law sources, which we mentioned: case law provided by the courts and legislation provided by Parliament. So case law comprises of decisions made by the courts and are published as law reports, which are considered as the primary and fundamental sources of UK laws. The effective implementation of the law depends on producing accurate law reports, which contain the facts, issues, and decisions, as well as the legal principles on which the judgment is rendered. The doctrine of judicial precedent is a peculiar characteristic of English law, where the court judgments recorded as a valid source of law for future decisions. Law reports can be categorized as the reprint of the full text, comprising of the judgment statement of facts and judicial decisions and reasoning made by judges, and further comprises of the additional materials such as legislation referred to for the case, summary of the legal issues, and a list of the case cited. Weekly law reports, these are published to serve as a draft of the cases, which will be updated in official law reports. All England reports, these are a collection of reports most commonly cited for recent cases. English reports cover a series of proceedings before 1865. Then we've got legislation. Legislation is the next one. So statutes that are enacted by the Parliament are legislation, which are acts of Parliament, orders in council, and can be statutory instruments as well. So these are important in regards to identifying, what the elements are that can be used. Then we go on to the next one, which is looking at secondary sources of law, and these are textbooks. These secondary sources are considered as background resources. They illustrate, describe, and they evaluate and analyze. They comprise of encyclopedias, amendments to the treaties, amendments to any laws, and any restatements. Secondary sources are a good way to begin research, and often have the primary sources citations. So when you're referring to any sort of secondary sources, they are cited with primary sources in them. They argue about the law, but they are not the law itself. Secondary sources includes encyclopedias, law journals, treaties, and are a great place to begin your research. So things like law journals, so the scope of journals is huge. Most are general, while others cover a particular field of law. Some have weighty scholarly claims, others are newsletters and aim to update you on the law to practitioners. Many publications contain a combination of studies and case commentaries that can help you clarify complexity of legal issues. The main database containing legal journals are things like, that lawyers use, but also students tend to use as well, is like Westlaw, LexisNexis, Hein Online, and these will help you identify certain concepts or research any cases. Textbooks are another secondary source, which are the best places to start researching any sort of legal subject. They comprise of textbooks for students written by academics, things like criminal law by Smith and Hogan, books by experts that resemble reference book, treaty on contracts and case books containing summaries on cases, particular subjects, cases, materials by Dine on criminal law. So these are books, and then we've got legal encyclopedias, a great starting point for law study, as it provides key points, cases, and legislation. England and Wales Laws of Halsbury, so these provide England and Wales only detailed in narrative. Parliamentary and non-parliamentary publications. You've got debates of Parliament, House of Commons and Lords papers, so reports, transcripts, any sort of committee statistics included. Non-parliamentary publications, and these include reports and briefing papers from departments such as Health Department, Defence Ministry and Justice. Most papers can be found on each of the department. A typical and often crucial challenge for a new researcher to get perspective of how these sources are applied and how they relate to one another, which they need to really be checking several researches. Divisions of the legal system. So the court system is in England, Wales, can be consisted of 5 levels. So it's made up of various levels is the court system. So we'll go through that with you. So the court system is made up of various courts, and each has a distinct role to play in the administration of the justice. There's clearly a hierarchy, and this determines which courts bind or influence the decisions made by other courts in the hierarchy. It's important to know that the role of each court and understand their relationship. So this is a hierarchy of the courts. So the court hierarchy establishes which decisions must be followed by other courts in the system. Generally speaking, the higher court, upper court is the hierarchy, the more authoritative its decision. So the table actually illustrates the court structure, and it tells you what each court does. So the first one on top is the Supreme Court, which is the highest court. So apart from cases concerning European law or the European Convention on Human Rights, the Supreme Court is the highest appeal court on civil and criminal matters in the UK. The Court of Justice of the European Union deals with cases concerning the interpretation of compliance with European law. The European Court of Human Rights has jurisdiction for cases involving the interpretation or application of the European Convention on Human Rights. The Supreme Court only hears appeal cases involving a point of law that is of public importance. It has appellate jurisdiction only. No cases, no matter how important, can start in the Supreme Court. The type of appeals that can be heard by the Supreme Court are things like, if the Brexit appeal, Article 50, things like if there was the case in regards to the child where his parents wanted to take him to get euthanasia to end his life. So these kind of public interest cases. The next one in the hierarchy there, as you can see in the diagram, is the Court of Appeal. The Court of Appeal is split into 2 divisions, as we can see, criminal division and the civil division. The civil division hears appeals on civil matters, and the criminal division hears appeals on criminal matters. Like the Supreme Court, the Court of Appeal only hears appeal cases. It will only hear cases that involve a question of law. Then we've got down the hierarchy is the High Court. As you can see, we've got the Queen's Bench division within the High Court, Family Division and Chancery Division. So the High Court comprised of 3 distinct divisions, as we mentioned. Queen's Bench, it is now the King's Bench Division, Chancery Division and the Family Division. Collectively, the 3 divisions of the High Court hear a wide range of civil cases. It is important to understand that in many cases, the High Court and the County Court have concurrent parallel jurisdiction to hear the civil cases. This means that both courts have jurisdiction to hear the same types of cases. The key cases are as follows. So civil cases with a value of 100,000 or less than 50,000 for personal injury cases should be commenced in the County Court. Civil Procedure Rules 1998, Practice 7A 2.1, where cases of a value of more than 100,000, more than 50,000 for personal injury, and the claimant can choose to commence proceeding in the King's Bench Division, the Chancery Division, or the County Court Division. The case can be commenced in the High Court where the case has complex facts or the outcome of the case has an element of public interest and the claimant believes the High Court is a suitable court. In all other cases, the case would be commenced at the County Court rather than the High Court. So you've got the King's Bench Division. So the King's Bench Division has the most varied jurisdiction of the three divisions. Generally, the King's Bench Division hears contract and tort disputes that are complex or involve substantial sums of money. It also contains several specialist courts, including administrative court, admiralty court, commercial court, circuit commercial courts, technology and construction court. When the court sits as a divisional court of the King's Bench Division, it can hear criminal appeals from Magistrates Court and the Crown Court and the judicial review hearings. Chancery Division of the High Court. The Chancery Division also hears a wide range of civil cases. It typically hears business or property disputes that are complex or involve substantial sums of money. The Chancery Division also incorporates specialist courts including the following: Business and Property Court, Patents Court, Intellectual Property Enterprise Court. And then the Chancery Division can hear a range of matters including the following: land and property disputes, mortgage matters, trust, administration of estates and probate matters, bankruptcy, partnership and company matters, and intellectual property matters. Then finally, within the High Court, you have the Family Division, which has jurisdiction to hear complex family cases. The Family Division have exclusive jurisdiction to hear international child abduction cases and cases that involve the inherent jurisdiction. It's important to note that the Family Division of the High Court and the Family Court are distinct courts. The Family Court is a separate court that hears most family cases. Some cases that begin in the Family Court but are considered to be very complex can be transferred to the Family Division of the High Court. And then we've got the County Court, which hears a wide range of civil cases. It is a court of first instance, but can also hear appeals in some circumstances. Claimants in civil cases can choose to commence proceedings in the County Court, as we mentioned earlier. The County Court tends to hear cases that are less complex of the lower monetary value than those considered by the High Court. As a general rule of thumb, cases with a value of less than 100,000 should be commenced in the County Court. Personal injury cases with a value of less than 50,000 should be commenced in the County Court. Then we have tribunals on the hierarchy. Some civil cases are considered by tribunals. Tribunals are specialist judicial bodies that adjudicate disputes in specialist areas of law. Technically speaking, tribunals fall outside the formal court structure, but they play an important role in the administration of civil justice. The Tribunals, Courts and Enforcement Act 2007 introduced a two-tier tribunal system. Generally, the first-tier tribunal acts as a court of first instance, and the upper tribunal deals with appeals from the first-tier tribunals. There's a separate employment tribunal. Tribunals hear a wide range of cases. So it can be things like employment law, where there's matters of appeal. It could be immigration appeals, tax tribunals, social entitlement and property matters tribunals. So tribunals come in different forms. And then we've got on the other side of this, on the diagram, if you have a look, we've got the Crown Court. The Crown Court is typically a court of first instance. It considers criminal law cases. It deals with serious criminal offences and only hears cases where the defendant is accused of committing an indictable offence or more serious triable either way offence. Indictable offences are very serious offences such as robbery, rape and murder. Triable either way offences are offences that can be considered by the Crown Court or by Magistrates Court depending on the seriousness of the offence. So to give you a good example of a triable either way offence is theft. So in some cases, theft can be considered a serious criminal offence because of the value of the property that has been taken or because of the circumstances in which it was taken. So, for example, the defendant abused a position of trust. These cases would be considered by the Crown Court. If a defendant appropriated a low-value item from the supermarket, like a bar of chocolate or packet crisps, it's likely to be considered by Magistrates Court. The allocation of tribal either way offences is based around the seriousness of the offence. Magistrates Court, the final one on the hierarchy. The Magistrates Court is a court of first instance. It deals with primarily criminal cases, but has some limited jurisdiction in respect of civil matters. The Magistrates Court also deals with first appearance of any defendant charged with a criminal offence. It deals with procedural issues and hears initial bail applications. Criminal jurisdictions of the Magistrates Court. So the Magistrates Court deals with all cases involving summary offences. Summary offences tend to be less complex and less serious than other types of criminal offences, so they don't require trial by jury. For example, most motoring offences are summary offences. The Magistrates Court also have jurisdiction to hear cases involving offences triable either way, so theft, burglary. In these cases, defendants do not have the right to insist on being tried in a Magistrates Court, but the Magistrates Court can accept jurisdiction for the cases they feel it's appropriate. For tribal either way offences, a defendant can insist on a trial by jury in the Crown Court. Where a tribal either offence is too serious or too complex to be tried by the magistrates, it must be sent to the Crown Court for trial. The Magistrate Court has limited sentencing powers. In particular, the Magistrates Court can only order a custodial sentence of up to 60 months or up to 12 months in total if the defendant has committed multiple tribal way offences. When determining whether the Magistrates Court has jurisdiction to hear tribal either way offence, the Magistrate Courts will consider the seriousness of the offence, any relevant pre-convictions, or whether the sentence powers they have are likely to be sufficient. If the Magistrates Court believes that the sentence powers are insufficient to deal with, it will reject the jurisdiction and the case must be sent to the Crown Court. So you can have a look, we've had a look at the hierarchy of the courts. So the highest courts, as we mentioned, we've gone through what each court does, what they deal with, is the Supreme Court, down to the Court of Appeal. High Court, you have the King's Bench, Family Division, Chancery, then the Court, County Court, Tribunals, and Crown Courts and Magistrate. And we looked at the severity of each one for how far it would go. The difference between criminal law and civil law. So a way to describe the difference was a summation by William Golgar, who defined it as the difference between a civil law and criminal law turns out on the difference between the two different objects which law seeks to pursue, redress or punishment. In other words, criminal law seeks to punish for an offence. Civil law seeks to achieve a remedy, for example, compensation. So civil law. So we're just going to go through civil law and criminal law so you have an understanding of what each one does. So in regards to civil law is quite different from criminal law. It's concerned with the rights and property of individual, people or organisations which may not always be protected by criminal courts. Civil law disputes between individuals and organisations often involves compensation. And there are different types of examples of civil law cases: family disputes, personal injury cases. Family law disputes could be things like divorce, dissolution, civil partners, personal injury, such as road traffic breach of contract, such as cases where money is unpaid or contract isn't honoured. Employment law, for example, employees suffers discrimination. Civil law cases often hinge on establishing whether or not the accused person or organisation legally known as the defendant had a duty of care towards the claimant. For example, an employer has a duty of care towards their employees. If an employee is injured at work, a personal injury solicitor must be able to prove the employee breached their duty of care and this was breach caused the injury to the claimant. Then you've got criminal law. Criminal law essentially relates to offences and breaches that negatively affect society as a whole, rather than that just one person. The area of law outlines what acts of Parliament deemed to be acceptable and unacceptable conduct in the UK. There are also offences which can be committed by a British citizen abroad, but then prosecuted under British law in England and Wales. If a person breaches criminal law, they're subject to criminal prosecution by the state. Criminal proceedings will usually be brought by the Crown Prosecution Service in the name of the Crown and will be held in Magistrates' Court by the Crown Court. Private prosecutions are also pursued by parties whose specific interest in the case of RSPCA or Royal Mail. Examples of criminal law things, criminal damage, sexual assault, murder, fraud, money laundering, or drug trafficking, drug dealing. If convicted, the offender will receive the penalty laid out in the relevant legislation. So if there's a law in place for it, they will receive that penalty. And the fundamental difference of each one is that criminal law seeks to punish, civil law seeks to remedy. So if there's a criminal offence being committed, then criminal law will seek to remedy. It will want to punish the person, whereas in civil cases, they will want to get any form of compensation. So the justice system in the UK. The justice system, one of three branches, the one each for England, Wales, and Scotland and Northern Ireland. This reflects its historical origins and the fact that both Scotland and Ireland and later Northern Ireland retained their own legal system traditions under the Acts of Union 1707 and 1800. The justice system is one of the three branches, as we mentioned. The other two are executive of the government and the Houses of Parliament. The UK famously and almost uniquely does not have a constitution that is contained in written constitutional instrument. It's found in statutes passed by Parliament and in common law, which developed over the centuries in decisions of the courts. Only two countries, Israel and New Zealand, are like the UK in this respect. These three countries differ in the way from almost all other countries. Such constitutional instruments, for instance, of the United States, which are one of the most well-known written constitutions, often have a higher status than ordinary legislation, and constitutional provisions can be enacted and repealed by special procedure. Changes in regards to the Constitutional Reform Act brought in a lot of changes in regards to simplifying the position of the Lord Chancellor. So the role of government in lawmaking. So how does the government make the laws? An Act of Parliament creates a new law or changes of an existing law. So it's an Act of Parliament that needs to go through that. Parliament is the legislative body who has the highest legal authority in the UK, checks the work of government. Parliament also debate and approve new laws proposed by the government. The House of Commons has the elected MPs, and the House of Lords together make Parliament. A bill can only become an Act of Parliament when the House of Lords and MPs both vote to support it. House of Lords power to reject a bill was limited by the Act of Parliament 1911 and 1949. A bill can still become a law if rejected by the Lords, provided it is reintroduced by the Houses of Lords. Organisation of the judiciary. So the organisational structure is premised on the following: a Constitutional Reform Act and the concordance set out in the responsibility of the Lord Chancellor Chief Justice as the head of judiciary. As one of the three branches of government, the judiciary works alongside the executive and legislative to uphold the laws. The judiciary role is to ensure laws are properly implemented. It does this by interpreting the law and then enforcing it. Another important role of the UK judiciary is judicial review, which allows the courts to review a decision or an action by public bodies such as government agency or local authorities that can overturn the decision if it was made illegally, or the proper procedure wasn't followed, or if it was irrational. If one of these is found, the court may strike down the decision, which may mean that the public body needs to make a new ruling, and the court can overturn primary legislation, but it can quash secondary legislation. There's a video there on the role of the judiciary in the UK, and Lady Hill is the one that's having in the video in regards to her role. So we've finished the learning outcome 1 on the business law unit, and these are the references that you could use. If you have any questions or anything regarding any sort of issues around it, email learnerwork@ukvarsity.co.uk. And also, if your submission of your assignment would be done on learnerwork@ukvarsity.co.uk. Please go on to Moodle for any additional reading or any additional sources that you need to refer to when reading around this area, and any ebooks. And we finished learning outcome 1 now. The next learning outcome, which we'll be doing tomorrow, is learning outcome 2. And thank you for attending today's session. Thank you.